All right. Welcome back to another episode of the American Man Podcast. Today we are on the Sixth Amendment. I'm here with my son Elijah. We've been going through the Bill of Rights and talking about the legal ideas behind them and kind of some of the details that have been written or ruled on ever since the founding fathers wrote the Constitution. So why don't you go ahead and read the Sixth Amendment, Elijah?
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
All right. So there's a lot of specifics in this one. It's some are kind of general, like due process and things like that. This one it has a lot of very specifics. So let's just unpack them kind of one at a time.
So this entire thing is kind of the rights of a criminal who's been accused of something. It's his rights of arguments and stuff, what he can do and stuff.
Right. And I would even hesitate to say the rights of a criminal, because what it says at the beginning is in all criminal prosecutions. So remember the mainstay of American judicial systems is that you are innocent until what?
Proven guilty.
That's right. So it's up to the state to prove that you committed a crime. It's not your burden to prove that you're innocent. So if they just accuse you of something and you don't say a single word at trial, if a jury doesn't believe that you have done whatever it is they say that you did, then they should find you not guilty, even if you don't present a single speck of evidence in your favor, right?
Mm-hmm.
So, so there's a lot of different parts here, and a lot of this, again, we've talked a lot about, the founding fathers. Why did they write certain things certain ways? And really, this one is pretty clear cut because there were just a lot of things that the king or the authority would do prior to the Constitution that really made it unfair for people who even had been charged with a crime, not much less found guilty. So the first thing they have, what is that? The accused shall enjoy the right to what?
A speedy and public trial.
Okay, so that's important. Speedy and public, right? So why is it important that they have a speedy trial?
Well, back then they'd be tortured and stuff, and it'd be long, several days.
Well, they could be tortured, and when it says speedy trial, it's not talking about the length of the trial. It's talking about how quickly you get to go to trial, right?
Like
so
they would be held in prison
for like a year, right? So essentially, they were being punished for a crime they hadn't been found guilty of. So speedy and public. Why do you think it's important to have a public trial?
Public is like around other people, right?
Right.
So that they can be witnesses too?
Well, so that the people can be sure that you got a fair trial, right? Because
otherwise it might cause a riot or something.
Well, if it's just you and a judge and a prosecutor, and the judge finds you guilty, you could go and claim that it was unfair. You could say, "Oh no, they didn't have any evidence," but it's your word against the courts. So it's important to have a public, trial so that everyone can see exactly how the system went, how the system worked, to protect you from, abuses of the system.
So like they can state something for you or something like that.
Well, it's not so important that the public, members of the public, actually participate in the trial. But you or I could go. In fact, I've gone to trials before and just sat in the back and watched them, you know, with various stages of the trial.
Mm-hmm.
I've sat in a murder trial and I've just watched, as an observer. And so if the state had been cheating or had, if they had been trying to force a conviction through without telling anyone, things like that, they can't just announce that, oh yeah, this person was found guilty, because the trial was public, so everyone could go if they wanted and watch it and see and make sure it was done fairly. Instead of just dragging you off and then saying, oh yeah, we found him guilty. The judge found him guilty, when it was really they call it a kangaroo court. And a kangaroo court comes from actually Australia, because remember what I said about Australia? It was actually a penal colony where England was sending its undesirable people, and it came to be known as kangaroo court when it was sort of like you already knew that the judge was going to find you guilty, and there was really it was a show. It was just a show that
they would jump to the evidence.
right. So that's what this is supposed to prevent, having a speedy and public trial. Now, it also says impartial jury. And we've kind of condensed this to what we call a jury of your peers. Who are your peers?
I'm not exactly heard that word.
Kind of like the people who are around you on a day-to-day basis. Those are your peers.
Like my siblings and.
Well, yeah, you wouldn't normally have family members on the jury, but like for a grown up, we're talking about most trials are for grown-ups.
Mm-hmm.
The people who live in the same community, and that's important because you want to be judged by people who understand your surroundings, your environment, and whether something is acceptable or not in that area, or whether you acted in a certain way that was normal, and also so that you can't be drug off to like a place that doesn't agree with maybe your religion or your political positions or something like that. They can't take you to a place where they know they can get a conviction just because of who you are, what you look like, things like that. So that's important as well. There are times when they'll move a trial, and that's if you believe you can't get a fair trial. And examples of that are typically if there's a lot of news or media surrounding an incident, a crime that was committed, and you're a very public figure. They might move the trial to another city or venue where you have a better chance of people not really knowing who you were, or not having heard the many facts about the case before, things like that. So let's move on then. To be informed of the nature and cause of the accusation, so they have to tell you what they're charging you with, and that's important. To be confronted with the witnesses against you. What does that mean?
Like they are there.
They're actually there.
Yeah.
Right. Yeah, and one of the bedrocks of criminal trials is the what we call cross-examination. And what that means is the state can call a witness. Let's just say it's a police officer who saw you doing something.
Mm-hmm.
Your team, your attorney, has the right to go and ask questions against that witness. So they, and that is really when a lot of cases start to fold. When you get a witness and they say they saw one thing, but then your attorney can get up and cast doubt on whether they are telling the truth or whether they actually saw what they said they saw, things like that. To be able to confront that witness and just not have, well, someone else said that you did this, but that person's not here, right? We have a whole world of what we call hearsay that is not admissible in court because we've decided that's not reliable, and
What
that's
if that person is just saying they said that?
right, exactly, and you have no way of kind of rebutting that. So you have the right to confront a witness who is testifying against you. You have the right to cross-examine that witness. Um, and there's a lot of complications that come up. What happens if that witness passes away before trial? All these different types of things. So then it also says to have, and this is related to that, to have compulsory process for obtaining witnesses in your favor. I'll just go ahead and break that one down.
There's
Basically,
a lot of words I don't know.
the defense has the right to what's called a subpoena, and it's a legal order to show up and testify. So if there's someone who, let's say you're being charged with running a red light, and there was someone on the sidewalk, and they saw what happened, and you think the light was green. You say, that guy over there, he knows that it was green. He was watching me when I went through through the light. You have the right to call that person as a witness to come and testify. And the state has to give you all the information of what they're going to be bringing against you. That's part of the sort of the due process that we talked about last time, and this compulsory process for obtaining witnesses in your favor. And then last, we have, and we talked about the Miranda rights last time about the right to remain silent and not to talk and things like that. This is another one of those, to have the assistance of counsel for your defense.
So to have the help of a person to help you prove against what you did or something?
Yep, you have the right to an attorney. Not just any person, but someone who's been trained in the law to represent you.
To make a good argument.
Correct. Correct. Yeah. Now, you don't have to take that. And I've watched people, self-represented, we call it, and they try to defend themselves. And sometimes they do a decent job. But, more often than not, you're better off, requesting an attorney. And because this is a right, this is a constitutional right. If you're poor and you can't afford an attorney, the state will actually give you an attorney, and they will pay for it. And that's what we call the Office of the Public Defender. So we have a group of people, so that the state employs their prosecutors, the people who are charging you, and the state also pays a group of people called the public defenders. And their job is to represent people who don't have enough money to pay for their own attorney.
It's also lucky if you're an attorney.
Yeah, but that can backfire. There's a lot of people who are attorneys who think that they can defend themselves, but if you're not like a criminal defense attorney, it's a really bad idea to try to defend yourself, because you might think but you don't. It's very specialized. So the only problem that we have, or one of the problems we have right now, is that there are not enough public defenders or prosecutors, for that matter. Both of those groups of people are overworked, and our justice system has a lot of faults in it when attorneys are just rushing through things. I've heard of plenty of times where the public defender didn't even meet with the accused person until right before the first hearing, and so they don't even know what's going on. Whether they are going to enter a guilty plea or not guilty plea, or what the basis of the crime is, and things like that. It's a really difficult position for a lot of people to be in. And it is sort of a shame that unfortunately we don't all get the best attorneys, or the attorneys with enough time and resources to put on a great defense for you. But it's certainly an improvement in the old systems, and fortunately, it's led to much fairer process for anyone accused of a crime.
Back then, it was just like you don't get any defense or anything.
Yep, tough.
You just have to try and prove it yourself.
Right. Yep.
And people barely ever did.
Yep. So we've come a long way from those times. So this is the Sixth Amendment, and it's essentially your right to a fair trial.